All right, I'm here with Kirk Tousaw, lawyer extraordinaire, a fantastic cannabis lawyer who has had many successes here in the province of British Columbia with cannabis law and other places. Kirk, good to have you on the show, back again. Now, I haven't had you on the show since this landmark decision, I guess it is, in the Owen Smith case, or at least it's a very pivotal decision here. Can you maybe just quickly give us a little bit of a background on what the Owen Smith case is, and then we'll get into the latest decision?
Sure, Jeremy, and thanks for having me on. I always appreciate the opportunity. Owen Smith was a baker for the Cannabis Buyers Club of Victoria, an organization that provides medical cannabis and medical cannabis products to patients in Victoria and elsewhere, founded by Ted Smith, no relation to Owen Smith. Owen was making cookies for the club one night in his apartment. The smell attracted police attention. He was ultimately arrested and charged with possession of THC for the purpose of trafficking, the THC, of course, being inside the cookies. Because he was making these products for the benefit of medical consumers, we launched a charter challenge on his behalf and supported by the club and its membership. And at trial a couple of years ago, in 2012, we were successful in having a judge declare that the restriction in the MMAR, Canada's, at that time, medical marijuana regulatory regime, was unconstitutional, violated Section 7 of the Charter, which guarantees Canadians the rights to life, liberty, and security of the person. And the judge struck the word dried out of the MMAR and modified the definition of marijuana to include all Schedule II substances. Those are all substances that are either cannabis or even the synthetic versions of cannabinoids like THC and CBD and others. That was appealed by the government. It only had precedential value in British Columbia, being a British Columbia trial court decision. But at least patients in British Columbia from 2012 to the present have been able to produce and possess non-dried forms of cannabis medicine, topicals, edibles, salves, concentrates, whether they be solvent extracts or solventless extracts, dry sip, ice water extractions, whatever the case may be. Of course, the government said, sky's going to fall, it's going to be terrible if this happens. None of those fearful predictions came true in the intervening couple of years. But we went ahead, went up to the Court of Appeal. We were defending the trial court's decision. The Crown was attempting to undo it. And we just learned a couple of weeks ago that we prevailed. We won a 2-1 decision in the British Columbia Court of Appeal. And 2 justices of the Court of Appeal felt that the restriction to dried cannabis only contained in the, they actually never mentioned the MMAR, but that restricting patients to dried cannabis only violated the patient's Section 7 rights. The judges said essentially that choices about the form of medicine and the way you take your medicine after it's been approved by a physician go to the core of what it means to live with dignity and autonomy in our free and democratic society. And so I was very, very pleased with the result. They did modify, the Court of Appeal did modify the remedy imposed by the trial judge. They said that he should not have altered the definition of marijuana, that that's too close to legislating, and that instead he should have sent it back to the government to fix the problem. Now, of course, he did that. He did give the government time to fix the problem. They didn't bother to do anything in the time allotted to them, or really since 2012. And in fact, they passed a new regulatory system, the MMPR, the commercial medical marijuana scheme that's currently in place, that again instituted a restriction to dried marijuana only, both for producers and for patients. So, I don't have a ton of confidence, obviously, in the government getting it right this time after 14 years of bumbling and stumbling through this program, but ball's back in their court. We know that the Charter protects the rights of patients to medicate with cannabis in the form that they find most appropriate for their particular symptom or condition. There was a dissent. The dissenting judge would have not allowed my client to even make his constitutional arguments because my client wasn't part of the medical marijuana system and wasn't a patient himself. That's an issue called standing. I happen to think that the dissenting judge is simply wrong on the law, and I think the Supreme Court of Canada jurisprudence is quite clear that you get to raise the unconstitutional constitutionality of a law or a regulation, even if it doesn't affect you personally, because if a law is unconstitutional as to one person, then it's unconstitutional as to everybody. With a dissent, what that really means is that the Crown has an opportunity to go to the Supreme Court of Canada. They've got to make that decision sometime in the next couple of weeks. I don't know what it's going to be, but we're certainly waiting to see what the next step in this litigation is going to be.
So as it stands now, Kirk, we're basically just waiting. But does this mean in the interim that patients are actually allowed to use extracts?
Well, it's an interesting, and really we're breaking new ground in this scenario, because the trial judge's decision was effective. Patients that were qualified under the MMAR and their designated producers in British Columbia have been able to produce and possess extracts, concentrates, and edibles as long as they're in conformity otherwise with the terms of their license for the last couple of years. That remedy was modified, but the modification of the remedy was suspended for a year. So my own view is, after thinking about it for a while, is that at least in British Columbia, the status quo remains. If you were an MMAR patient or designated producer, you're entitled to continue on as you have been producing and possessing other forms of marijuana other than dried marijuana. If you're protected by the injunction handed down in the Allard case. If you're an MMPR, customer of a licensed producer, of course, licensed producers are not entitled to make these derivative products currently. But the patients ought to be able to produce them and possess them at home, for example. So you can make your own cookies or teas or things of that nature. And, of course, anybody that's making derivative products, you need to have a pretty good knowledge base before you step into it, because it's fairly easy to make cookies that are a little too strong, and you might have some unwelcome side effects if you consume too much cannabis edibly. And of course, if you're making things like solvent-based extracts using butane, for example, you really shouldn't be doing that in a residential setting. You shouldn't be doing that if you don't have a tremendous base background in what you're supposed to do, because it can be unsafe. It isn't always unsafe. It's safe if done properly. But if you're not doing it properly, you're risking your own safety and the safety of people around you. So you've got to be very, very cautious with things like that. Mm-hmm. The decision also ought to be binding across the country. Decisions at the Court of Appeal level are binding on trial courts across the country. And so theoretically, if a patient were charged, for example, with possession of hashish, cannabis resin in Ontario, and was a qualified medical patient, they ought to have a charter-based defense. Really shouldn't be charged at all. The Crown really shouldn't charge them at all. But if charged, they ought to have a charter-based defense to those charges. And of course, if people are in that situation, they certainly are welcome to contact me at either www.tousawlaw.ca or at info@tousawlaw.ca.
Right, because as it stands, it just being in British Columbia, it doesn't set a direct precedent, but, accordingly, those lawyers should be able to use what was used in this case in their defense, right?
Yeah, it does have a strong precedential value. It's supposed to be binding on trial courts across the country. Often if you're in another jurisdiction and you try to bring up Court of Appeal decisions from outside your province, they're not treated necessarily with the same force as Court of Appeal decisions within your own province. Mm-hmm. But, under the law of Canada, they are supposed to have binding effect. And so if you face those kinds of situations, and hopefully not very many people do, because the Crown really ought not be charging patients with crimes arising out of their possession of these products. But nevertheless, if you do face those kinds of difficulties, then you should get good legal representation, whether local or if you wanted to call my office and set up an appointment to talk about it. That's certainly something I'd be happy to do. The other interesting aspect is, what are LPs going to do in response to this decision?
Right.
I'm sure that these producers would love to have the ability to make derivative products. I'm sure patients would appreciate the ability to obtain products that are standardized, that are of known dosages, contain known active amounts of the ingredients. That's not to say that compassion clubs and the expert bakers like Mr. Smith across the country aren't already doing that. But if we're going to have legal access to derivative products in this country, everybody ought to be able to participate in that industry.
Right, this is just the beginning, I think. But
let's hope so.
Kirk, now, as for the Supreme Court of Canada, it's basically they make a decision if they want to appeal this, is that right?
Well, with a dissent on a point of law, the side that got the dissenting opinion but ultimately lost the case is entitled to go to the Supreme Court of Canada automatically. So you don't have to make an application for leave to appeal. The Supreme Court has to take the case, is my understanding. So that means that if the Crown elects to appeal, of course they don't have to, they could just take the decision and leave it as is. But if they elect to appeal, then it looks like we're on our way to what I've sort of called the third period of these proceedings, the third court, the final court. And it'll be the first time the Supreme Court of Canada has taken a medical marijuana case of any kind. So obviously excited about the opportunity if it comes, and going to do my best for both Mr. Smith and all the incredible patients and members of the Cannabis Buyers Club of Canada that came forward, supported this case, shared their stories, sometimes very, very difficult stories with the trial judge to demonstrate just how important these products are to maintaining their quality of life.
Mm-hmm. Now, Kirk, would it be different fighting this in the Supreme Court of Canada, or would it be? I mean, this one looks like it's a pretty solid case you had. You had a lot of judges already finding on your side. Do you think the Supreme Court would find anything different?
Well, I certainly hope not, and we'd have the advantage going in being the respondent in an appeal, because there's deference given to the decisions, both of the trial judge particularly on the facts, and also deference given to the trial judge and the Court of Appeal on the law. And so we start with a bit of an advantage in terms of the burden of proof necessary to undo a decision at the Supreme Court level. And, I think recent Supreme Court of Canada jurisprudence in the area of Section 7 suggests that we're on solid footing. I mean, you never know. Obviously, 5, I think, of these Supreme Court justices were appointed by Prime Minister Harper. I think that that's not necessarily worked out for him in the way that he perhaps thought it would when he was stacking the court with his appointees, because he's been dealt some fairly significant blows to some of his public policies in the Supreme Court of Canada. Most notably, of course, the prostitution or solicitation case. But again, you never know, and it's certainly going to be exciting. It's going to be nerve-wracking. And if we're privileged enough to go to Ottawa and speak to the Supreme Court of Canada about medical marijuana, I just hope they understand how very, very important this is to hundreds of thousands of Canadians right across this country.
No kidding. Now, Kirk, with Health Canada, since this case happened during the MMAR, the earlier system, and Health Canada was told to modify this. Now they have modified their system with the new MMPR system, but it didn't actually, as you said, address this extracts issue. Does that mean Health Canada is going to have to go and do some more modifications here? I mean, what exactly does that mean for Health Canada?
Well, the ball's in their court. I mean, the Court of Appeal has said, government, we're going to give you a year to respond legislatively. That's a long time, obviously. The Court of Appeal didn't mention or wasn't specific to the MMAR, and if you have a right under Section 7 under one regulatory enactment, presumably that right carries forward under other regulatory enactments. And so if it's arbitrary to prevent patients from accessing these products, these medicines, under the MMAR, it's just as arbitrary to prevent them from accessing it under the MMPR. And I think hopefully all Canadians can agree that what we really want is what's best for patients. And I think it's about time the government got off its ideological posturing on this issue and simply implemented a medical cannabis system in this country that works for everybody. And of course, Jeremy, as you know, and as you've talked about so many times, the real evil here is prohibition. If we didn't have a general prohibition on marijuana in this country for all persons, all adult persons, well, then we wouldn't be fighting in the courts and spending millions of taxpayer dollars trying to expand access for sick and critically and chronically ill Canadians. We just wouldn't need to do it because the substance wouldn't be illegal in the first place. So,
right.
The right choice, obviously, is let's just legalize cannabis and let's work on cost coverage and reimbursement for the cost of medicine for those who are medically qualified to access it. Because I think that what we'll find is a reduced dependence on pharmaceutical substance, increased
Kirk, could Health Canada come back, as we've seen sort of before in some of these cases where the government is told by the court to change their regulations, and they come back with, you know, a sort of little teeny tiny change that barely changes anything and doesn't really affect it? Like, yeah, you know, before it was designated growers, the government said it was unconstitutional to just have one person growing for one person kind of thing. They came back and said you could grow for two people or something along those lines.
Yeah.
Is there something they could do like that in this case?
Well, I mean, it's the ball's in their court and their government, so they can, and hopefully they'll act in good faith. But again, as you mentioned, the history of this program and the history of their responses to previous declarations of invalidity by the courts, various aspects of the medical marijuana regime, hasn't given me a tremendous amount of confidence they're going to do the right thing this time. And you know what? At some point, the whole edifice is going to come crumbling down, because if you don't have, it's very clear that if you don't have a working medical cannabis system, then you're not entitled to prohibit cannabis generally for all people. So, you know, the government's in a dicey position here. I mean, there's only so long I think the courts are going to sit well with the government not acting in a manner that's responsive to the jurisprudence in Section 7. That said, I mean, I think we've seen it with the prostitution issue, for example. You know, the Supreme Court of Canada says, look, this situation is unconstitutional. Your laws are harming the very people that you say the laws are there to help. And the government comes back and proposes a new set of laws that does the exact same thing. So it's hard to have a great deal of confidence in our government on this issue. But you got to hope at some point that the suffering of Canadians and the incredible benefits that medical cannabis products can bring to people, you know, cracks through that sort of cold ideological exterior and you know, maybe actually touches some people with a little bit of compassion. But it's anybody's guess how the government's going to respond to this. You know, they could just sit back and do absolutely nothing and take the position, you know, hey, patients can go ahead and we don't care if they make cookies in their kitchen with their LP purchased dried marijuana. Make all the cookies you want, make all the tea you want in your own home. And, you know, while that's going to work for some people, I think that kind of response would really put a lie to all of the concerns for safety that they claimed they had in the course of this trial. Because at the end of the day, unless you're an experienced maker of edibles, you know, it's really a trial by error type situation when you're making a batch of cannabis cookies. How strong are they going to be? How weak are they going to be? Not that there's anything that's going to jeopardize your life or really your health in any way. You might, if you eat too strong a cookie, have an unpleasant psychoactive experience of short duration that leaves no negative long-lasting effects. But, you know, is that what we really want to do? Do we really want our grandparents who have no exposure to cannabis in their lifetimes suddenly getting a package in the mail of cannabis and crushing it all up into like 2 cookies and then eating those cookies and having very, very serious psychedelic experiences? I certainly don't think that that's an appropriate situation for the government of Canada to allow to occur through its inaction. I mean, the right thing to do, absent pending prohibition, is number one, stop taking away people's right to produce medicine on their own. And number two, for those people who want to engage in the commercial production and sales of cannabis-based medicine and cannabis-derived medicines, have a reasonable regulatory regime that permits them to do that. I mean, that's really the fix to this problem. And it's a relatively simple fix that the government can implement simply by modifying the MMPR in a couple of ways.
Kirk, could this lead to something larger than just the medical marijuana side of things? I'm thinking of the Hitzig case, where at the time the court struck down several parts of the new MMAR and basically told the government that it until they had fixed the medical program, all of those laws were unconstitutional. Could there be a similarity in this case where extracts themselves, because there isn't a way to get them some way legally in a good way from the government, the laws themselves become unconstitutional for everybody?
Well, certainly that's the jurisprudence arising out of Parker and Hitzig that if you don't have a working medical cannabis exemption scheme, you're not entitled to prohibit cannabis generally. Unfortunately, in sort of recent times, the remedies that the courts have imposed for unconstitutionality have been very limited remedies. Declarations of invalidity of the restriction to dried marijuana, for example, and not a complete striking down of the Controlled Drugs and Substances Act, despite the fact that my clients have instructed me, and on their behalf, I've sought to have the entire CDSA declared to be unconstitutional. I know other lawyers have done the same thing, and I know other self-represented people have done the same thing. The courts seem, at this juncture, to be reluctant to impose that kind of sweeping remedy. But like I say, we've got about a 13, 14-year pattern of what I would call, and what I have called in court, bad faith and contemptuous responses by Health Canada to the decisions of courts in this area. And at a certain point, I think the courts are no longer going to countenance the government, in a sense, thumbing its nose at these Section 7 decisions.
Right. So now, Kirk, just last question here. If I am a medical patient here in British Columbia and I want to use my extracts, should I feel safe in doing that now? And I mean, at this particular point, there's not much for those people to worry about, is there?
Well, I think if you're a qualified medical patient under either the terms of the Allard injunction or you've become a new medical cannabis patient under the MMPR, then you should be in a position where your possession of and production of these types of medicines is lawful, as long as you're otherwise in conformity with the regulatory scheme and the terms of your license. In other words, right now, for example, you're restricted to possessing only at maximum on your person 150 grams of cannabis. Yes. Well, that applies to edibles as well. So if you had, cookies weighing, say, 300 grams, then technically you're going to be not in conformity with that 150-gram limitation. And so you may face some legal jeopardy. Now, I was chatting with a Crown lawyer, and we were sort of musing through what the possibilities were arising out of the Court of Appeal decision, and his comment was, I can't really see us, the federal Crown, charging patients for possessing cookies in light of this decision, unless there's some other factors. And obviously you hope that's the case. I mean, you certainly hope that police aren't arresting sick people in possession of marijuana-based medicines. And you hope the Crown, if those people are arrested, would decline to pursue charges. But, for the time being, I think in British Columbia and across the country, patients at least ought to be in a position where their possession of cannabis-based medicines is lawful. And you do have a protected Section 7 right to make those fundamental choices.
Excellent, Kirk. Thank you so much for your time today. We'll definitely have you back as this case progresses. Fingers crossed. Yeah, it was great.
That's right, Jeremy. And I appreciate the opportunity. And again, if people want to sort of keep abreast on that development in this case and anything else, my website's at TousawLaw.ca.
Excellent. Thanks a lot, Kirk. We'll talk soon.
Thanks, Jeremy. Yeah. Cheers.